Welcome, everyone. My name is Teresa Friel, and I am with JER HR Group. We're excited to have you join today's webinar on the federal overtime rules. Our speaker today is Hillary Ross of counsel with the Denver office of Fisher Phillips. Hillary is JER's go-to employment attorney. Fisher Phillips is an international labor and employment firm with almost 600 attorneys in 41 offices across the United States and Mexico. Hillary brings a wealth of experience to the table. Hillary represents employers in labor and employment-related litigation at both the state and federal levels, including appellate matters. Her experience includes a broad range of topics from discrimination, retaliation, and harassment cases to employee classification, wage issues, and executive agreements. Hillary has successfully represented clients in the courtroom and before key agencies, such as the EEOC, or the Equal Employment Opportunity Commission, and the Colorado Civil Rights Division. We are thrilled to have her here to share her insights with us today on this new law. So I will let you take it from here, Hillary.
Thanks, Teresa. Thanks for that nice introduction. And thank you to JER HR for having me here today. And welcome to everybody. Thanks for joining us. We're going to be talking today about the new federal overtime rule. But before we get to that, I wanted to address just some general housekeeping issues. The first 3 bullet points you'll see on this slide relate to technical issues. So if you're having any technical concerns, you can take a look at that. Hopefully we won't have any more. And if you have any issues that pop up as you've been doing, please feel free to put a note in the chat. Any sort of technical issues will be addressed immediately. As far as other questions, we're going to hold those to the end, and then we'll address all of the other questions at the end. So you're eligible for HRCI and SHRM credits for this presentation, and you'll get some more information about that via email after the presentation. The slides, if you look at the bottom of your screen, you'll see that the slides are available there, and so feel free to take those. And there's also going to be a survey at the end that we would be happy for you to fill out. It'll give us some more information about some topics and other things that you might want to hear about in the future. So I wouldn't be a lawyer if I didn't give some sort of disclaimer. This is a very complex area of law, as a lot of employment law is. And so this is going to be a general overview today of exemptions, and especially the new changes that are coming here in January. If you have any sort of specific concerns, we definitely encourage you to reach out to your favorite employment lawyer to talk about those concerns to make sure that you're compliant. So we'll start with a little bit of background about the Fair Labor Standards Act, the FLSA. So it has 4 main requirements. The first requirement is payment of a minimum wage, which is currently $7.25 an hour. It also requires premium pay, so overtime pay, for any work performed in excess of 40 hours a week, and that's a time and a half. It requires certain record keeping by employers, including accurate time records, and it also includes some limitations with respect to employment of minors. So what do you have to compensate employees for? Employees need to be compensated for all hours worked. Hours worked is a defined term, and it's defined as time that the employer suffers or permits to work. So anytime that you allow employees to work, or you know or should know that the work is being done, then it's required to be paid. So these issues come up pretty frequently in situations where you've got a requirement that employees seek approval for overtime. Whether they seek approval or not, if it is time that's been worked, then they're entitled to be paid for it. The other time that this comes up, especially post-COVID, is that everyone has access to emails, Teams messages, things like that from home. So when you have employees who are responding to calls or Teams messages or emails outside of their normal working hours, that's still time worked. So what are exemptions? Exemptions are just that. They're any sort of exemption from one or more of the FLSA's requirements that we just discussed. Some of those exemptions only apply to overtime requirements. Some apply to both the minimum wage and overtime requirements. But I think the most important thing to remember is that the default is that everyone is non-exempt unless proven otherwise. So in other words, unless you have an employee who you are sure that an exemption applies to, that employee is automatically going to be non-exempt and entitled to overtime. So the executive exemption, the administrative exemption, the professional exemption, and the highly compensated exemption, those are commonly known as the white-collar exemptions, are exemptions from the minimum wage and timekeeping requirements. So what they require is that the employee show that the employer show that the employee is paid at least the minimum weekly salary, that they're paid on a salary basis. So in other words, their pay is expressed as a salary and not as an hourly rate, and that they meet the duties test for the exemption that they fit into. What we're going to talk about today is the change to the DOL rules, which is going to increase the minimum weekly salary for the exemptions. So I think it's important to get a little bit of background to understand how we got here. The FLSA has been around for a very long time. It was initially passed in 1938. So as you can imagine, there's been a lot of changes and a lot of rules since then. But fast forwarding to 2016, the Department of Labor issued an overtime rule that was to be effective on December 1st of 2016. It would have provided for an increase for the minimum weekly salary for exemption to be increased to $913 a week. And it would have provided for some automatic increases after that. This rule never took effect. Texas court entered a preliminary injunction that blocked the rule from becoming law nationwide. So fast forward again to 2019, and the Department of Labor issued another rule. So January 1st of 2020, there was an increase to the minimum salary to $684 a week, and no automatic increases as had been proposed under the prior rule. It also increased the highly compensated employee salary requirement from $100,000 to a little over $107,000. And it also put in some ability for employers to use non-discretionary bonuses to meet that requirement. So the most recent rule, we'll call it Overtime Rule 3.0, increased the salary threshold from $684 to $844 per week. And so that was effective back on July 1st of 2024. So that has already taken effect. So the next step is that it's going to increase to $1,128 per week, effective January 1st, 2025. And then there are going to be automatic increases every 3 years based upon a wage survey. So for highly compensated employees, a similar sort of two-step analysis. The rule increased the salary threshold from $107 to $132,954 effective back in July. And then there's going to be a second increase in January of 2025 to $151,164, and there will be automatic updates to that as well. So now that you know that this is going to happen, what do you do? Well, the first thing to do is to review your pay practices and fix any mistakes now. The good news is that while January 1st is just around the corner, you still have some time to take a look at things and make sure that you're compliant before then. So the first thing to do is to take a look at any employees that you have that are classified as exempt and who are paid at or less than the new thresholds, or close to that, since there are going to be updates in the future. And while you're doing that, it's always my recommendation that you also analyze to make sure that not only are the salary requirements being met for those positions, but also the duties tests. The duties tests are complicated and jobs change over time. And sometimes the job that the employee is performing is not the same job that's in the job description. So as long as you're reviewing these jobs, it's a good idea to make sure that the duties test is also still being met. So you really want to make sure that employees are exempt. You can use an attorney-client privileged review or audit to do that. So what is that? So that would be someone like me or your favorite employment lawyer taking a look at all the job descriptions and making a determination as to whether or not you're compliant. It would be extremely important, especially in a state like Colorado, where I am, to make sure that all state law requirements are met because those are different than the FLSA requirements. So you can use this new rule to justify any sort of changes that you need to make. So when we talked about the requirements to show that an employee is exempt, we talked about the salary basis test. There's no change to that. That's going to remain the same, and employees still need to be paid on a salary basis in a predetermined amount. That must be paid free and clear. You'll see that's in quotes, which essentially just means that you can't make any changes to an employee's salary based upon the quality or quantity of their work. So there are no partial week deductions that can be made for any week that the employee works. There are some exceptions to that, of course, and you'll see those are listed below. The most common and important being things like PTO, FMLA leave that's been used, sick days, that sort of thing. One thing that you might want to make sure that you have, as long as you're performing this review, is a safe harbor. So a safe harbor is a policy that is usually in the employee handbook that states that you prohibit any sort of improper deductions. It will include some sort of complaint mechanism. So an employee who thinks that they've had an improper deduction made knows where to go to complain about that. And then it's important, if you have any of those complaints, to reimburse employees within a reasonable time for those improper deductions. And why this is important is that if you have a safe harbor and you follow it, and you demonstrate a good faith commitment to complying with the FLSA, then you don't risk losing the exemption and having an employee that you accidentally treated as non-exempt turning out to be treated under the law as non-exempt. So let's talk a little bit about the executive exemption. So executive exemption means an employee whose primary duty is managing the enterprise or a customarily recognized department or unit. So this would be someone who's running your accounting department, running your sales department, someone who is a manager, someone who customarily and regularly directs the work of 2 or more full-time employees. So obviously, if you've got part-time employees, if you've got 4 part-time employees, that would be the equivalent of 2 or more full-time employees. In order to be executive exempt, an employee must have the authority to hire or fire, or at the very least to make suggestions or recommendations with respect to hiring and firing, advancement, promotion, that sort of thing, that are given significant amounts of weight. So the administrative exemption, we'll talk a little bit about that one. So that's an employee whose primary duty is office or non-manual work relating to the management of the business or the employer's customers. The work must include exercise of discretion and independent judgment as to matters of significance. And we'll talk a little bit more about what that means. But as you can imagine, that's critical. And figuring out what discretion and independent judgment means is important. So here is sort of a general list of what you look for. So whether the employee has the authority to formulate and implement management policies or operating procedures, carries out major assignments in the conducting of the business or the customers, whether the employee performs work that affects business operations to a substantial degree, has the authority to commit employer in matters that have significant financial impact. So say, for example, to contract on behalf of the employer, or the authority to waive or deviate from pre-established policies and procedures. So this is where employers can definitely get in trouble with the administrative exemption. If you've got an employee who performs all of these duties, but has to look at a policies and procedures manual and can't deviate from that, then that's someone who can't exercise discretion, independent discretion. So we'll talk a little bit about the professional exemption. So there are 2 different types of professional exemption. There's the learned professional. So that's someone whose primary duty is performance of work requiring advanced knowledge. Usually this is what you think of as doctors and lawyers and teachers, someone who's gone to school to do the thing that they're doing. Creative professional would be someone whose primary duty is in innovation, imagination, originality, talent. So I like to think of that as something like a choreographer. And lastly, the highly compensated employees. So that would be someone whose primary duty is office or non-manual work, which the employee performs at least one of the exempt white-collar duties that we just talked about, and receives a total compensation of what's currently $107,000, $432 per year. And obviously, as we talked about, that's going to go up to $151,164 a year on January 1st. So after you've had the opportunity to review reclassifications and find out who you've got who may be close to the threshold or under the new threshold that will take effect in January, you have two choices at that point. You can give them a raise to above the minimum salary and be prepared to do that every 3 years, or you can reclassify them as non-exempt and start paying them overtime for all hours worked over 40 in a work week. So if you decide to reclassify employees, there are a couple of things that you're going to want to think about. First of all, how are you going to pay them? Are you going to pay them as hourly employees, or are you going to pay them as salaried non-exempt, which would mean that their pay is expressed as a salaried amount for a particular number of hours per week, and then they're entitled to overtime over that. And then the other thing you're going to want to think about is how you're going to want to calculate that employee's hourly rate. There are a couple of different ways to do that. You can take what the amount of overtime that you think that employee would be working and divide it by 40, and then figure out what their effective hourly rate would be. And it's important when you do that to understand the impact of the regular rate, which would include bonuses, as we'll talk about here in a minute. So with respect to bonuses, you need to make sure that the bonuses that you provide your employees that you understand whether they're discretionary or non-discretionary. I can tell you this is something that comes up frequently in my practice that I advise employers on pretty frequently, because what employers think are discretionary and what's actually discretionary are sometimes two different things. Anytime you have a bonus that is something that has been a promise that's been made to the employee to induce them to work, sort of what you think of as the yearly bonus, something that has criteria that need to be met in order to be paid, that's a bonus that is likely to be non-discretionary. And so that would be part of an employee's regular rate. And so discretionary bonuses are really sort of like things that would be not expected by the employee, not planned for, and not part of what their original compensation package was expected to be. So calculating the regular rate is tricky because, like I said before, overtime payment, it doesn't require that you pay 1.5 times the employee's base rate. It's 1.5 times their regular rate, which would include the payment of any sort of discretionary bonus or non-discretionary bonuses or incentives. So that has to be included in your overtime pay calculation. So these are the steps in order to do that calculation, but JER HR can help you with determining how best to do that, and so can your favorite employment lawyer. So here are a couple of different ways, examples of how the regular rate of pay can be calculated. I'm not going to go through these in detail, but it just shows how the regular rate can be impacted by the receipt of a bonus. What I expect as employees are reclassifying is that there's going to be more litigation. That's what happens every time there's a change made to the law. But I think there are going to be more issues that come up with respect to miscalculating overtime, and in particular, the effective hourly rate. And any sort of bonuses, whether or not they're actually discretionary or not, and whether they should have been included in the regular rate. I think there are also going to be some lawsuits that end up coming up with respect to misclassification of employees, but that's always been a fertile area of litigation and collective actions as well. So the next step that you're going to want to take is you're going to want to determine how this affects the rest of your operations. So if you're going to reclassify people from exempt to non-exempt, there are some considerations. First of all, do you have an effective timekeeping solution? You may already have that. If you have employees who are non-exempt, you may already have a timekeeping solution that you can use and then have those new employees track their time through that. But if you don't have that, that's something that you're going to need to implement. It's also important to determine how this is going to affect benefits. Many employers have different benefits requirements for employees who are exempt and employees who are non-exempt, and things like sick leave, different vacation requirements, that sort of thing. So you're going to want to look at how this would impact these newly reclassified employees. You're also going to have to train them, because you're going to need to train them with respect to any sort of timekeeping requirements, meal and break requirements, depending on what your state law requires. And you're going to have to train their supervisors on these new procedures. The next one is the impact on morale. This is a huge thing to consider. For whatever reason, employees seem to look at being classified as exempt as being somehow prestigious or the sign of being a professional, when really it's just an FLSA classification. So sometimes reclassifying employees to non-exempt will have a negative impact on morale. Employees also who are not used to doing so don't necessarily want to have to track their time, and they like the flexibility that comes along with being classified as exempt. This is a particular consideration, I think, with managers who are no longer classified as exempt and have to clock in and out with the employees that they supervise. And they may look to that and feel that that gives them, less of an authority over these employees that they're supervising. So even if their pay remains the same, employees may view a switch to being non-exempt as a demotion, even though it's not. So you'll have to weigh the impact on morale, and also, as we'll talk about, the way to message it to make sure that you have the least impact on morale. So you want to be prepared to proactively communicate and answer questions about why you decided to reclassify them. It may be helpful to review and summarize market studies if you have access to that information, so that you have some facts to back up your decisions. Always remind employees that they're valued, and let them know that you're required to make changes in light of federal government requirements. The Department of Labor, in issuing this rule, has made it very clear that it's their goal for more employees to be classified as non-exempt and to be eligible for overtime pay. And so you can explain to your employees that those decisions are meant to keep your business compliant with the law. So you're going to want to provide a written communication to each employee about whatever changes are being made to their compensation, any sort of new responsibilities that come along with that, like we've discussed, timekeeping or meal and break requirements, and other requirements and implications that this reclassification may have. So as we talked about before, the FLSA is not the only law that you have to consider. So consider multi-state implications. You may have different requirements that you have to meet in other states with respect to giving notice of any sort of changes to wages or job duties or that sort of thing. So make sure you take that into account in your communication strategy. Also, as this states, and we'll talk about it a little bit more, some states have salaries above the new federal threshold. If anyone here is from Colorado, you'll know our exempt threshold is significantly higher than the federal thresholds. So, always keep in mind looking at state requirements along with any sort of federal requirements. So as we discussed, if you've got different policies that apply to exempt and non-exempt employees, you're going to want to take a look at those and review them and find out whether or not they still apply, or how you want them to apply to these newly reclassified employees. And you're going to want to look at your remote work policies. Remember, as we talked about before, any time worked that is outside of office hours, including returning emails or answering Teams messages, things that previously exempt employees might be used to doing, has become time worked. And so it's going to be important to make sure that your remote work policies reflect non-exempt employees working in those positions. So the next step is going to be developing some training for your managers and for these newly reclassified employees. With respect to record keeping requirements, you're going to need to get employees used to and compliant with tracking their time. You're going to need to get your managers used to enforcing that requirement, because as an employer, you are absolutely required to keep that information. And if you don't have it, then the burden is on the employee to say how much they work. And so it's really critically important to have accurate timekeeping records. Like I mentioned, working from home policies, you may want to reevaluate whether certain employees have access to email on their phones or Teams from home. It just depends on what your operations are and what works best for you. Also, things like meal and rest breaks. Do you want to track them? How do you want to track them? What's required under state law? We talked a little bit about overtime approval. So a lot of employers have requirements that overtime be approved, and that's certainly something that you can do. But as I stated before, if overtime is not approved, it is still time worked and needs to be paid. So managers and employees will need to be trained as to that approval process, and also making sure that they're compliant with it, and if they're not, what the consequences are. And it may be that your managers need to be trained that if there are any after hours requirements, and you don't want people working unapproved overtime, that they need to take the after hours calls and emails. But in any event, you need to train your managers and your newly reclassified employees as to how to deal with those situations. So legal challenges to this new rule. So on May 22nd, so before the first round of changes to the salary requirements took place in July, business groups started opposing this, trying to either sidetrack or keep the rule from becoming enforced at all. What's going to happen? We have a little bit of an idea, and we'll talk a little bit about what this is. But you may be thinking, is this really going to happen for real this time, since it didn't happen before? But you really can't count on that at this point. It's really important as an employer with this upcoming January 1st requirement that you make sure that you're compliant and are able to address your employees' classification issues and be compliant as of that time. So there are some pending lawsuits with respect to this. So the state of Texas sued the Department of Labor in the Eastern District of Texas, which happens to be the same court that blocked the 2016 rule from going into effect in 2017. So the state is arguing that the rule is not valid because it's replacing the FLSA's duties test with a salary test, which is really something that has been going on for a long time. But on June 28th, the judge did grant a preliminary injunction blocking the rule from taking effect, but only in the state of Texas. So it's limited to Texas right now, and it doesn't affect anybody else. But that's not to say that there won't be future lawsuits or lawsuits that are currently pending that block the rule from going into effect in other states or somehow more widely. So it sort of remains to be seen. But essentially, the new rule doesn't really make a change to how the FLSA has been interpreted since for quite a while. There's the salary basis has been something that has been considered since 2004. And you have to be careful what you wish for here, because at the very least, the salary basis test is an easy way to look at an employee's classification, and it's a bright line test. Do they meet the salary basis requirement or don't they? Prior to that, there were these long and short form tests that were made to determine whether or not classifications were met. And it's confusing, and it could make it a little bit more difficult to figure out whether you've got employees who are truly classified as exempt or not. And unfortunately, any sort of ambiguity creates litigation. So the other thing that is impacting this is the most recent Supreme Court decision in Loper Bright Enterprises versus Raimondo. You may know this as the Supreme Court case that overruled the Chevron standard. So under the Chevron standard, any sort of federal regulatory rules were given deference, and were required to be given deference by courts. Now that the Chevron rule is no longer in place, courts do not have to give these rules, such as the new DOL rule, the same level of deference. This is going to, at this point, I don't think any employment lawyer really knows what's going to happen, or really any environmental lawyer or any other lawyer that deals with the federal government on any level. We don't really know. But we can say that when courts are allowed to second guess these interpretations, what's probably going to happen is there's going to be inconsistency. So if you've got a court that is analyzing the exemptions in the Northern District of California, they may make a very different decision that's made in Florida. And that's going to create some confusion when you've got operations in multiple states as to what the requirements are for your employees. So something just to look out for that's going to continue to create some uncertainty in the future. So it's important to be compliant with the FLSA, but it's important to realize why. If you're not compliant and you've got an employee who is misclassified as exempt, they're entitled to remedies if they sue. They can sue on an individual basis, they can sue on a collective basis on behalf of other employees, and they can receive things such as back wages, any sort of unpaid overtime. Again, if you don't have a timekeeping system that shows how many hours those employees worked, then they can come up with their own calculation that's a reasonable amount of work that they said that they performed. There's a 2-year limitations period looking back for those sort of damages, but it's 3 years if it's determined to be willful, which that's a complicated determination, but frequently employers are found to have acted willfully if they misclassified an employee. Another important thing to remember, especially for smaller mid-sized business owners, is there's individual liability. The definition of employer under the FLSA is extremely broad, and it includes anybody who essentially had decision-making authority over an employee. And so frequently what I'm seeing in the FLSA collective actions that I spend a lot of time defending is that managers and owners are named as individual defendants. Employees are also entitled to attorney's fees, which can unfortunately sometimes dwarf what the actual wage liability ends up being. Sometimes these are not insured claims. If you have EPLI insurance, I always recommend taking a look at your policy and finding out what your coverage is to see if these types of wage claims are covered, or if they are, whether it's just the cost of defense or whether it would also include any sort of award that's made or penalties and things like that. So here's some final considerations to consider. Like I said, make sure you review applicable state laws. So the FLSA is the floor, it's not the ceiling. Anyone in Colorado or California knows that the requirements for exemptions are going to be different, and some usually significantly more stringent. Like, for example, for the administrative exemption under Colorado law, the employee has to be working in managing the employer's operations, not the employer's client's operations. So it certainly narrows significantly who is administratively exempt under Colorado law versus the FLSA. There may be different minimum wage and overtime laws. Colorado, California, many other states also have higher minimum wage. And the overtime laws and requirements might also be different. So say, for example, California, if you have employees who work more than 8 hours a day or 40 hours in a week. So that's an additional overtime requirement that isn't present under the FLSA. So again, I'll just reiterate that there's going to be litigation over this. So the best thing that you can do as an employer is to be prepared and do the best that you can with the information that you have to be prepared to be compliant with the rules as they change. So overall best practices, it's my recommendation to conduct audits routinely. to make sure that you're compliant. The only surefire way to determine whether compensations decisions are consistent with federal, state, and local laws is to conduct an audit. Those can be done internally. They can be done with an attorney. So then if you've got issues, then that's under attorney-client privilege. So you can consider which one you want to do based upon that. You'll want to review the exemption classifications as we talked about. I would also recommend looking over any sort of independent contractor classifications. That's another place that I see employers get in trouble a lot, is by misclassifying people as independent contractors. The other place I'm seeing a lot of litigation, and in fact just settled a case relating to this issue this week, is pay equity. So there's the Equal Pay Act that requires equal pay. And then there's also for example, the Colorado law, the Equal Pay for Equal Work Act that is somewhat similar, but fairly new. And so there's a lot of litigation that I'm seeing relating to that. So it's a good idea to take a look at your compensation and make sure that you don't have any potential equal pay issues. And then you're going to want to take steps to correct any sort of misclassifications or disparities. I highly recommend that you seek out advice of counsel before you do that, just to make sure that you do it in a way that minimizes your liability as much as possible. Obviously, anytime you misclassify or you reclassify an employee, there's the chance that the employee is going to understand that perhaps they were entitled to overtime that they weren't paid, or that their pay was being changed because of a pay disparity relating to their gender, and there may be back wages owed. So again, it's very important to talk to a lawyer and make sure that that's done in a way to limit liability as much as possible. Like we talked about, examine and revise policies and procedures to make sure that they fit your employees and how you want your operations to run based upon how they're going to be classified. You're going to need to train all your decision makers and your employees to make sure that they are compliant with any sort of requirements of any new classification that they have. And as we talked about, messaging is really key. But January 1st is a good time to be making any sort of changes. That's a time where changes are sort of expected. And so I think, the fact that the law is taking place then, the change is taking place then is fortuitous timing for employers. So this is another thing that's really important to remember. A lot of times employees end up exempt for these three reasons. First of all, that everybody treats this job as exempt. Every company that has an employee that does this particular function treats them as exempt. That doesn't necessarily mean your employee is. It's important to start with the analysis from the beginning, assume they're a non-exempt employee, and only classify them as exempt if the exemption fits. Frequently, employees want to be classified as exempt, either for reasons because of prestige or their impression of what it means, or because they just don't want to have to track their time. Sometimes I've heard employees say that the employee agreed to be exempt. That might work at the time, but what happens is if that employee sues later, there's no way to enforce that agreement, because an employee cannot waive the requirements of the FLSA, including overtime pay. And so don't fall into those traps. We understand that doing any sort of reclassification of employees is a tricky process, and especially because of the morale issue. But the liability can be so extreme. It's really important to make sure that we don't fall into these traps in particular and misclassify employees simply because it's easier. So with that, I'll take any sort of questions. I see we've got some in the Q&A. Okay, so the first one I'll take is from, I'm going to hopefully pronounce this correct, Sherry. Please explain how an employer determines if an employee is a highly compensated employee as opposed to an executive, and the salary that should be in place on January 1st, 2025 for those two types of employees. What it really comes down to is the duties test. If you've got an employee who meets the executive exemption duties test, then you can classify them as an executive. If you've got, say, for example, you've got someone who performs some of the duties, then potentially you can classify them as a highly classified or a highly compensated employee if then you want to pay them at that threshold. But you would want to start with whatever exemption you think their duties would meet, and then move to the highly compensated exemption if that one doesn't fit, if that makes sense. So the next question is from Alma. Can you talk about how to handle non-exempt employees who travel extensively, including overnight travel? So that is tricky. There are rules relating to how travel time is to be handled for employees who are non-exempt. This is one, unfortunately, I'm going to give you kind of a lawyer answer. It's going to depend on the employee and the type of travel. Some travel needs to be required or needs to be paid. Sometimes it doesn't. It depends on the type of travel, how often it's done. But this is another area where you're going to want to review your policies pretty carefully and make sure that your policies are in line with travel performed by non-exempt employees. Okay, so the next question is from Teresa. What if our operations are only in one state, but we have employees that work remotely in other states? That's a great question. And actually that comes up a lot with employers. In fact, it's come up this week already for me with a client. If an employee is performing work in a state, they are an employee of that state. And so it's really important to make sure that you are meeting any sort of state requirements. This is something that has really exploded since COVID, when a lot of people moved and moved to different states, or employers started hiring more remote and contingent workforce because of COVID. But it's important, say, for example, if you have your main operations in Idaho and you've got an employee in Colorado, then you have a Colorado employee, and that employee needs to be paid according to Colorado law. The next question is from Lisa. I work in a public school system. Teachers fall under the learned professional exemptions duties test, but some of our teachers do not meet the salary requirements. Are we required to pay them overtime, or are they automatically exempt regardless of the salary? That's a very good question. I guess I'm going to have to say I'm going to need to look into this. And the reason being because, well, if you're a public employer, sometimes requirements are different. So that would be one that I would want to look into very specifically before I would be comfortable giving an answer. What consequences, this is a question from Aaron. What consequences are legal if you have not given permission to work overtime hours, but the employee chooses to work extra hours? That's another really great question, because this comes up a lot. Your choices are never to not pay the employee for that time. Your choices are to discipline them. So you can move through your progressive discipline that you have in your employee handbook. Ultimately, you can terminate an employee if they continue to work overtime that is not authorized. But the one thing that you can never do is not pay for that time. So this is a question from Jewel, which is, the administrative exemption seems vague. Will you be discussing this status further? It is vague, and it is one of the most difficult ones to determine whether or not there's compliance. So I would absolutely agree with you. I think that this is one we could have an entire webinar on in order to really sort of get into the meat of it. And like I mentioned, a lot of states have different requirements. So the requirements under the FLSA and Colorado law are totally different. So this would be one that, if that's a topic for some other day, I'd be more than happy to speak on that alone, but it is pretty vague. And so determining whether or not an employee fits within those requirements, it would be a great place to start an audit, and maybe to make that a privileged audit to make sure that you can use the privilege should you need to make changes later. This is another question from Alma. Will we need to pay non-exempt employees who are required to be on call after hours overtime for those hours? So it depends on what on-call means under for your organization. And it also depends on state law, because California, for example, has very specific requirements with respect to waiting to engage or being engaged to wait. which are technical terms under California law as to whether or not the time is compensable or not. So it really depends on what on-call means. And a lot of it comes down to how much time the employee is expected to actually perform work while they're on call, how much freedom they have. Can they go to the movies? Can they go to the mountains? Can they go skiing? Those are always the concerns here in Colorado. So it depends on how restricted their freedom is. If it's just that they have to call their cell phone and maybe once a month they'll get an actual call that they have to step out of whatever they're doing and take the call, then maybe that's not compensable time. If they're called in multiple times per on-call shift, then potentially it is compensable time. So that would be something that I would highly recommend looking into, if you have questions about that and talking to an attorney about that. So the next question is from B. Bissell. How do you find out about the duties tests? So the duties tests are part of the FLSA. And if you go to the Department of Labor website, there's actually a lot of documentation with respect to, and a lot of it is very employer, HR person friendly with respect to what the different tests are. We went over in not a whole lot of detail, just basic descriptions of what those duties tests are. But there's more information that can be found on the DOL website. And also, like I said, because they're frequently different under state law, you would want to look at whatever the duties tests are under state law as well for any employee if they're different. I know in Colorado, the Colorado Department of Labor and Employment, the Division of Labor Standards, has a bunch of different, they call them info sheets that you can look at that have more information. But this is another area where if you've got a particular employee where you have concerns about their classification, it might be best to talk to an attorney about it. So this is a question from Blanche. Does the minimum weekly salary apply if an employee is part-time as well? So, okay, if I'm understanding the question, it would be, do you have to pay, if that employee is going to be part-time, do you have to pay the full minimum weekly salary that is required by the FLSA? I mean, I think the answer to that is, it would be better to classify that person as non-exempt, because if they're only working a certain number of hours per week and it's not full time, then they're not going to be working any overtime. And so you're not going to want to pay them a salary that would cover 40 hours if they're only working 20, for example. But this might be a situation where if you've got an employee who works overtime some of the time and they work part-time most of the time, that you want to take a close look at what their duties are and what they're doing and what their hours are, and determine how to pay them as a non-exempt employee from there. Okay, so this is a question from Deborah. If the position meets the duties test, but the incumbent works less than 40 hours per week and therefore their salary is prorated, does the threshold amount get prorated as well? It's a similar sort of question. Or is it 58,656 applicable regardless of hours worked per week? So if you've got an employee who is an exempt employee, they're paid per week a flat amount no matter how many hours they work. And so theoretically, if you've got an employee who you are paying, who works less than 40 hours a week, but they're salaried exempt, that's accounting for the fact that sometimes they're going to work more than 40 hours and sometimes they're going to work less than 40 hours. I think anytime you've got an employee that's working less than full time, like I just mentioned, it might behoove you to take a look at it and see if it would be more appropriate to pay them on an hourly basis. But since you can't make any sort of deductions from an exempt employee's pay for time that's worked that's less, for any sort of quality or quantity changes to their work, you don't get to prorate the amount that they work based upon the number of hours that they work. Okay, and this is a question from Sherry. Please explain how to determine if an employee is a highly compensated employee. I think we mentioned that a little bit earlier, but essentially it has to do with whether or not they perform. It always has to be some sort of office or non-manual work. So say, for example, you have your lead lead electrician, for example. That's someone who's performing manual work. So regardless of what they're paid, they're not a highly compensated employee. So someone performing office work who performs any of the exempt duties that we talked about. So, duties relating to the administrative exemption or the executive exemption, and is paid at the level that is required for a highly compensated employee. I think, okay, it looks like we have a few more. Glad we had some extra time at the end. Okay, so this is a question from Emmy. What about commission-only paid employees? Do we need to track their hours? So we did not talk about exemptions relating to sales employees who are commission only. This would be something that, again, you would want to make sure that you do an evaluation of whether or not they meet the requirements for being a commission only salesperson, and what that and whether or not their pay is sufficient for that. So that would be one that you would want to look at the employees individually and their positions to find out whether or not they meet the requirements. This is from Jewel. Should professional certification qualify for a professional exemption even without a college degree? Usually not. This comes up a lot in the context of paralegals, actually. So paralegals generally are not exempt, even though they have professional certifications. Usually it requires a course of study that does require a college degree, like a teaching job or a doctor. I think sometimes physician's assistants can be exempt, but usually a professional certification is not enough, but that would certainly depend on what that certification is. Okay, this is a question from Jennifer. If we have an exempt employee and opted to make these salary changes over time, with one jump in January and map out another jump in 6 months, are we liable for back wages and other liabilities back to January 1st? So if I'm understanding this correctly, this would be an employee who you would not bring up to the new FLSA requirement as of January 1st, but you would take them up, their salary up at that point, and then bring them up to the level required by the FLSA in 6 months later. The answer is yes, you would be liable for any sort of back wages back to January 1st. Anytime that employee was not paid the required amount for being exempt, you would be required to pay them for that time, including any overtime. And going back to what I was saying about tracking time, if this is someone whose time wasn't being tracked, if they said they worked 15 hours of overtime a week and you don't have anything to demonstrate that they did not, that liability could be very high. Let's see. This is from Jennifer. The January change will have a significant financial impact on our privately owned company. How likely is it that this rule will be blocked? Should we move forward with implementing it? And once we implement the change, there's no going back, even if it ends up being blocked. I think that I would not suggest that you assume that this rule will not take effect. At this point, the July change already did take effect. The injunction that has been entered at this point is not nationwide. Litigation is extremely unpredictable, and something else could happen between now and then. But I think it would be very dangerous and potentially subject you to a lot of liability to assume that it's not going to go into place. But this is a situation, if it's going to have significant impact on your company, this is a situation where talking to an employment lawyer and getting creative about what sorts of solutions that you may be able to implement might be worth the time and expense, because there may be ways to implement this that will have less of an impact on your organization than you originally thought it might. So, that's absolutely a situation where some creativity on the part of an employment lawyer may be able to help you. Okay, so this is from B. Bissell. Job title does not necessarily mean it is automatically an exempt position or administrative exemption if actual duties don't align. Yes, that's correct, and that's a great point. I see this come up a lot with job titles that have the word manager in them. So the job title is not controlling at all. You can call an employee any job title that you want. What is key is the duties. I just was dealing with a client who has people in a position that they call a manager, but they don't actually manage anybody. So they aren't managers, they manage processes, but it's really important to make sure that the duties line up and the job title is really irrelevant. So this is a question from Pam. If we are a nonprofit, are we required to follow these DOL requirements as well? This is another great question, and I actually represent some nonprofits. This is one that comes up for me a lot. The answer is it depends, but probably. There are very few nonprofits that are carved out, and so it's a very specific carve out. So for the most part, the answer is going to be yes. Most nonprofits do have to comply with the FLSA requirements. But that would be another situation that talking to an attorney about what your specific compliance requirements are would be really important. All right, this question is from Din. If the exempt employee got paid based salary plus stipends for doing projects outside of their regular duties, should the stipends be counted towards their total salary for the FLSA salary test? So it sounds like the employee is paid one way for their regular duties, but then they do some additional work for the employer on the side. One thing to be very careful about in that situation is that all of the work that is performed, if it is work performed by an employee who is potentially non-exempt, is potentially non-exempt. So this would be a very fact-specific question. So I can't really say whether or not that would be, because it would really depend on what the employee was doing. I'm sorry, I can't give a more specific answer for that. Okay, so this is from Juliet. If an exempt employee is already at a salary over the $58,656 rate, California, yes, then can we continue the current cadence of pay, essentially no change in January 2025? That's correct. If you already are in a state like Colorado or California where the pay requirements are higher, there's no requirement to make any changes because you've already got employees who are paid over the salary threshold. It's always a good time to take a look and make sure that you've got employees who are still meeting the duties tests, but no, you are not required to make any sort of pay changes at that point. It looks like we have a couple more minutes. We can take a few more questions. So this is from Sherry. So it sounds like it's arbitrary and it's up to the employer to decide if they want to classify an employee as a highly classified employee or executive if they wish to pay that higher salary. Yeah, kind of. I mean, I don't know if arbitrary is the word that I would use. Employees may be able to be exempt under more than one exemption. That's pretty common for more than one exemption to potentially apply. So if you've got someone who's performing executive duties and are also earning the higher salary, they may be both executive exempt and also exempt under the highly compensated employee. So this is a question from Melissa, who's here in Colorado. I have a complicated question relating to Colorado seasonal camp ski exemptions. Can I email you a question hard to explain over an email? Yes, you'll be getting my contact information. Feel free to send me an email. I'd be more than happy to chat with you about that. And then I'll take maybe one or two more questions. Let's see. This one's from Christy. Would a best practice be to switch them from salaried non-exempt or to a salaried non-exempt so they keep the morale piece but are eligible for overtime going forward and review past pay practices for overtime potential back pay? It's gonna depend, but I'm inclined to say probably yes. I think that when employees are still treated, when they still have a salary, but they are now entitled to overtime, I do think that does tend to play a little better morale-wise. You're still going to have the potential morale issues relating to having to track time, which employees don't generally like to do. So you may have that come up still. But if you're reclassifying someone at this point in January simply to relating to the new salary requirements, then there's not going to be any sort of overtime potential back pay. If you're just reclassifying someone who's potentially been misclassified, then yes, there is potential back pay. And like I'd mentioned, if you're going to make changes like that, I highly recommend talking to counsel so that you can do that in a way that is going to minimize your liability as much as possible. Okay, well, I think that's about all the time that we have.
Wonderful. Well, thank you again so much, Hillary. That was great. Such a great presentation, full of great information and just some guidance on how to move forward during this change. A lot of great questions. So thank you all for the great questions. I would like to remind everybody to complete the survey after the webinar. It's helpful information for both Fisher Phillips and JER HR Group on what we can, bring to you in the future. Wonderful. Thank you so much.
Thanks, everybody.